Previously on Insurance Suits. I always tell my students to remember the acronym DICE, which is Declarations, Insuring Agreement, Conditions, uh, Endorsements, Exclusions, and then the other D is Definitions. Because some of that is like
Nice.
really important. Yeah. So I mean, it helps, and then
We're
hi.
back.
Oh my God.
Oh, sorry.
No, this is great.
Team.
This is what happens when we don't plan anything. Hi, because we're so excited.
Hello.
We're so excited. Uh, we're back doing Policies 101.
Love it.
I
We
know.
are ready to jump right in.
Yeah. So I mean, you don't need to know that I'm Chantel. You don't need to know
I'm Amy Johnson.
that. But I will say before we begin, do be sure to like, follow, subscribe to our podcast, forward it to your friends or whatever on your favorite distribution channel, because that helps the algorithm like forward it onto other people and we become all famous, and we get lots of money that way. Not really, but I have no idea how that works, but there you go.
I wouldn't mind a little extra cash.
No, I wouldn't either. Let's get into it. Welcome to the Insurance Suits podcast, a bi-monthly discussion of the people who are involved in insurance and lawsuits. We haven't talked about like what what entails a contract, because I think everybody kind of knows that, but I got a little acronym for that one too. So anyway, there you go.
Oh, let's hear it. Let's hear it.
Okay. It's CLAC, CLAC, which is consideration, legal purpose, acceptance, and consideration. Did I already do consideration? Yeah, whatever. Those are like the four.
You know, that that would be a good acronym for someone studying for the bar. That
There you go.
brings me back to my bar prep days.
Like when you need all those.
We learned all acronyms
Yeah.
so that when we were filling out like the essay portion,
Mhm.
we could just write it on the side and then work every one of those into the essay question.
Fun fact, and this just is one of those things that just kind of chaps my hide, is that as an adjuster, I'm not allowed to talk about the law, of course, but because I'm not a lawyer, I don't have a law degree. And especially when I'm doing like a bad faith claim where we're just dealing with claims, and I have to, even if I'm talking about the Unfair Claims Practices Act, I kind of have to say, well, this is the standard, or whatever. I can't sit there and go, well, they violated code number, blah, 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 or whatever. A, because that's a trier of fact, fine. But B, what chaps my hide is the fact that I, as an adjuster, I have to know this stuff, because if you think about it, when we are settling a claim, I have to know what a contract is for settlement. Has there been consideration? Has there been an offer? Has there been an acceptance? Is there a legal purpose for this? So if I'm dealing with a minor, I can't get settlement. Anyway, we're off topic. Sorry. I'm going on my soapbox. I'll get off now.
You're not off topic though. You're not off topic, because that's exactly what a lot of people forget to do, is to check. I mean, most of the issues that you just talked about in the contract elements are where I would start with the policy, which is the deck page, because that is the names of the two parties. Let's not forget the carrier's name is on the top of the deck page.
Right.
And the name insured is on the deck page as well. So you have the parties of the contract, you have the meeting of the minds, because the deck page, it should show what premium is being paid for each coverage that of insurance is being provided. It hits every element.
Can I say helpful hint for for plaintiff attorneys, please? and I probably don't want to, but stop filing lawsuits against Lloyd's of London. Lloyd's of London is not an insurance company. So what
A
you're talking
syndicate.
about, what you're talking about with the declarations page, when you're seeing the name of the insurance company, it's not Lloyd's of London. It would be certain underwriters subscribing to Lloyd's of London, you know, or certificate, certain underwriters of Lloyd's London subscribing to certificate number, blah, 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 blah.
Or the
And
syndicate, right?
yeah, it's the syndicate. And sometimes there's multiple syndicates. Anywho, yeah. So declarations page is the first one, and it gives your named insured, like you said. Policy period, very important. You know, premiums, not so important, I don't think. Personally, in regards to, I don't know, a first party lawsuit, maybe it is. I haven't seen it though. A description of business, that's pretty important. And even if it's not a commercial, it would still have the description of the house, maybe like, you know, frame or stucco or whatever. And that could be part of the issue that a claim got denied or, you know, whatever.
Right. Well, I've seen I would agree with you on the premium aspect. For me, it's not so important of the amount, but what I always look for, because I've actually run into cases where it should generally say on the deck page, coverage is provided, or the coverage provided of the different coverages listed. The only ones that are provided are the ones where a premium is shown.
Oh yeah. That's a good point.
You know,
That's a good point.
now
Yeah.
what I think is really interesting, I dealt with it, was like, for example, an insured thinks it's buying a property policy, but this was an odd case, but there was a premium shown under the builder's risk coverage.
Mhm.
So the
Which is
deck page was
property.
there isn't a property policy, yes, but there was a property form and a builder's risk form attached as part of the policy.
Right. And so that's super
I mean, you've got,
confusing. Yeah.
so the premium, whether a premium was paid and how it was determined, whether it included a commercial property component, ended up becoming like a huge part of the case.
Absolutely.
But,
okay. Yeah. I know
but
where you're coming
otherwise,
from.
but I would agree. I think it's as long as I don't get it, I've gotten into it before, but the calculation of premium and the amount isn't something that I'm looking at.
I think that's going to be one of our other interviews that we have, because I know what we're talking about is, you know, you and me just talking and kind of talking about lawsuits and insurance and but we also want to interview some of our AIMCO members. Like we've already had the interview of Michael, so which was great. I mean, fascinating. Sick 'em bears. But yeah, you're right. I have seen some claims where the insured says, you know, oh no, I have XYZ coverage. And I'm like, no, you don't, because you didn't pay a premium for it. And you really have to go back as a claims adjuster. You have to go back to the agent or the broker, and then you get into the whole duty of like, who's the agent of the insurer, yeah, blah blah blah, what representations were made.
Right.
Another podcast topic.
And I'll give a shout out to the AIMCO members. I'll tell you right now, the members that are in AIMCO it's like a wealth of experience, a wealth of knowledge. There are so many times where I have picked up the phone and I'll tell you, anyone I know in AIMCO who I have called just as a, can I bounce this off of you kind of question, has always taken that call, had a conversation, a discussion. Anybody will help if you know an AIMCO member. And I think the website is aaimco.com.
That's right.
Is that
Yeah.
right?
Yeah.
You can look up the members on there. You can find members. You can look at their people's CVs. Hopefully everyone's got theirs updated. I need to update mine. But the AIMCO people are awesome.
Yeah.
I have just so enjoyed getting to know. I mean, Chantel, you and I just enjoy having conversations with you.
Yeah.
And I really enjoy being able to use someone as a resource. I mean, we've got people who do workers' comp. We've got people like you and I who really can kind of, we're a jack of all trades. We can jump in. But then we have people who do audits.
Yes.
And, you know, looking through claim files, trying to figure out how to tighten up some of the issues that are coming up in the claim, in the claim department.
Absolutely.
And underwriting experts. I mean, it's crazy. The wealth of knowledge is amazing.
This episode of Insurance Suits is sponsored by the American Association of Insurance Management Consultants, or AIMCO, a nonprofit association comprised of insurance and risk professionals. Find out more at www.aimco.com. You're absolutely right. Like, I'll give you another example of the wealth of knowledge coming from my background, though. Again, tying it into like the declarations page is the fact that on the declarations page, you will see usually coverages. And by coverages, I don't necessarily mean, although this will be what's listed, is, you know, homeowners or coverage A, coverage B, coverage C, or personal business property or whatever. That's not necessarily what I'm talking about. Sorry, I got cat hair floating all around. I'm still trying to keep the cat off camera. And what I am talking about is like usually on the bottom, they'll say something like endorsements or policy forms or something like that. And I can't tell you how many times I have seen, and I will say this is a lesson for lawyers, tips for adjusters, whatever, is make sure you know the addition date, because the addition date matters. And so often, especially with certain underwriters who I won't mention, the agents or the brokers or the MGAs, the managing general agents, will only put down the base form, which, for example, the commercial policy is the CP0010. That's the base form, but they don't talk about 06/11, which is June 2011 was like one of the last times that it got updated, or maybe 10/22, which would be October, 2022 or whenever.
Right.
I mean, they aren't updated all the time, but the issue, of course, is that an October 2022 policy is obviously going to be different than a June 2011 policy. That's why they updated it. And it could just be one word, but it could be one of these things that we saw with the whole pandemic, where we're having to go like, well, of course, everybody knows what property damage or, physical damage, quote unquote, means. So now maybe they are putting that in the policy. So now they're having to update it or whatever. So if you don't see that on the declarations page, the addition dates, as an attorney and as an adjuster, you need to find out what that addition date is before you can even adjust the claim.
And check the effective date of the endorsements.
Yes.
Because now some endorsements can be, when I was in-house, there was a policy of an underwriter was not allowed to backdate an endorsement after a loss, especially if it was going to change the coverage position.
Right.
But a lot of endorsements are added onto the policy with an effective date going back to the inception date, like the first day that the policy is in effect. But, if you're adding a location on, you need to make sure that you see the effective date.
Yeah.
So if a loss occurred at that location before it was added on to the policy, chances are you're not going to provide coverage. I mean, it could be that just looking at that one thing could be the difference
Oh, yeah.
between paying a claim and not paying a claim.
Absolutely. So when we get on to, like I mentioned, insuring agreements, one of the best pieces of advice that I had heard for attorneys is to know that for insurance policies that I am now giving my cat some milk from my tea, and he's not interested in it. Is insuring
he
agreements.
a coffee or a tea drinker?
Yeah, neither. He's just a pain in the rear, is what he is.
A milk drinker.
So insuring agreements. Sorry, squirrel. Is one of the best advices that a piece of advice that I heard was for all attorneys is there's a whole policy after the insuring agreement. The insuring agreement simply says we will, pay for covered cause of loss, or we will pay for losses that you become legally liable for, or whatever. But that doesn't mean that there's coverage, because there's the whole condition part of it that we just talked about. We haven't talked about endorsements and exclusions yet, but that is the whole thing too. So insuring agreements, be sure you read, as Bill Wilson often says, and he's a member of AIMCO, read the whole policy, read the policy, all of it, every single time.
Well, and just because you have to flip back and forth doesn't relieve anyone. And I'm not just talking about the policyholder. I'm talking the adjuster too, because there are so many times where I know someone didn't turn back. They looked at the exclusion. It had a term in quotes, what's defined. And then you have to look at the definition, and then you have to go back to the exclusion, and then it refers to a different part of the policy. And then you could have an endorsement that changes the exclusion that you just read and went and got a definition for.
Right.
And hey, the fact that it's tedious and time consuming doesn't mean you don't have to do it. And it could be the difference of picking up that there's an and instead of an or.
Exactly.
That could make the whole difference of a claim being covered.
And you're absolutely right. It can be. And that's a very important difference. As I like to tell my adjusters when I was a claims manager, the endorsements or the exclusions are where the underwriters taketh coverage away, and endorsements are where the underwriters giveth it back. And you've got to read all of it. And usually what I would do is, once I got to the exclusions and the endorsement part of it, I would read, because it would usually say this, supersedes section F, or whatever. I would go back to section F and draw a line through it. So I know if I'm reading it a couple of months later, and you should always reread your policy every single time, multiple times, because you're always going to catch something. But, that way I know not to pay attention to that one particular part.
Well, yeah. And here's the thing. I mean, you can even have an exception to the exclusion.
Oh, yeah.
So,
yeah.
You've got the insuring agreement, you've got an exclusion, you've got an exception to the exclusion, and then you get toward the end of the policy and there's an endorsement that changes all the language.
Yes.
So
here's my question for you. Do we put our right foot in and shake it all about as we do the hokey pokey? That's kind of what it's like boiling down to.
Well, that's a good way of describing it too, though, because it's not as though you're just opening up a barrel and throwing confetti in the air, and whatever lands on the ground is what you apply. I mean, you have to do the dance, and you have to get through. Once you get through and you know how to read a policy, it can change your whole perspective on how you view the coverages. And let's be mindful too. I mean, the insured is it's, I can't call it a duty, it's an obligation though, to establish coverage in the first place.
Yes, thank you. I am working on a case right now, and I think that's a part that's very confusing for most attorneys and insureds. Adjusters know it. Is that it is the duty of the claimant, either first or third party, to establish that there is, I guess, coverage for this particular loss. But then it would be the insurer's job to say if there is an exclusion or an endorsement or, whatever that applies to it so that this loss would be covered. So the insured would have to prove that the policy applies, I suppose. I think you said it much more artfully than what I am saying, but it then goes to kind of what the next point is a named peril versus a special form cause of loss. I never use the word all risk, quote unquote, and I absolutely drill it out of my risk management students, and I drilled it out of my adjusters, because you hear the word all risk. And again, we experienced that in the insurance world during the pandemic. Well, it's, everybody's telling me it's all risk, so everything's covered. No, actually, the proper phrase is everything is covered except what's excluded, and that's not nearly as sexy.
Right. Well, and if it's a limitation or an exclusion, if the carrier wants to not pay, they have to show that they don't have to pay. If an insured wants coverage, they have to show that there's coverage.
Right.
It makes perfect sense to me, but there are so many times so a lot of my expert work, it's kind of funny because I represent as a lawyer primarily all insurance companies. But my expert and consulting work is about 50-50 each way.
Mm-hmm.
So policyholder versus carrier on the expert side. And I'll tell you what, there is a lot of mistakes that get made on both sides of that equation.
Sure.
I have rarely seen a situation where, I remember reading about like a carrier after Katrina and how they sent their adjusters down, their CAT team down there with explicit instructions to not pay and underpay. I still don't think that was true. I mean,
Not
I have
pay.
rarely
Oh,
seen
wow.
that
Oh,
kind of
wow.
pattern in practice, like lowball the offers to homeowners getting lost during Katrina.
Yeah, that's bad faith.
I don't think it's that systematic. I just don't think that's, I have rarely seen instances of that.
Yeah.
But
yeah.
I've always told people, this is a bit off topic, but I love saying this. When I was representing the carrier, when I was in-house, I went to settlement conferences all over. And I would say to the mediator every time, listen, we pay what we owe. We don't pay what we don't owe. It's as simple as that. We pay what we owe. We don't pay what we don't owe. Now, we might be wrong sometimes. We misread the policy.
True.
And we, should have applied that exclusion differently. But we pay what we owe. We don't pay what we don't owe.
True.
And that's a fundamental, people could get on board with that.
I think that's true. And I think that's something that is not well understood, especially in the lay community for the policyholders and for the third party claimants is that we can disagree, and it doesn't make it bad faith. It doesn't make it, meaning that you're going to get a multi-million-dollar settlement or whatever. And we can make mistakes because we are human, both the insurance company, the adjuster, the attorneys representing the insurer or whatever. And again, that doesn't lead up to bad faith or give rise to a violation of our good faith duties. We just have a dispute. That's all that is. And so, on that note, I think we've kind of gone over Insurance Policies 101. Yeah, I know. So coming up, we're going to have some guests and finish talking with some of our people in the AIMCO community.
Super awesome guests too. These
Absolutely.
people, I'm telling you, you've got to watch some of the upcoming podcasts with the AIMCO folks, because they're awesome. They are awesome.
This wraps up another Insurance Suits podcast. I'm Chantel Roberts, and I'd like to thank Amy Johnson. Yay. We'll be back in 2 weeks. We'll be having an interview, so that would be super awesome. You can contact me at cmroberts@cmrconsulting.net for consulting or training purposes on claims matters. In the meantime, if you need an insurance consultant or expert witness, go to AIMCO, which is www.aaimco.com.
Hey, and I am looking forward to our next podcast where we will have a great guest. And if anyone needs to reach out, give me a call, have a question, an issue, looking for expert on bad faith or claim handling or across any product line, you can reach out to me at amy.johnson@Hepler, HEPLERBROOM.com. You can always get me at my direct dial, 312-205-7726. And I will just tell you, our firm changed to Zoom-based phone calls. So lucky for me, you can always, that'll get me on my cell phone too, because I have the Zoom now.
Wonderful. Absolutely wonderful.
And thank you, Chantel. I really enjoy having these discussions with you.
Me too. It's so much fun. We'll see you in 2 weeks.
Bye. Take
Bye.
care.